And let us know if you want to reserve any time.
2 minutes for rebuttal, Your Honors.
2 minutes, okay.
All right, may I begin?
You may.
Okay. Good morning, Your Honors. May it please the court. I'm Taylor Payne. I represent the plaintiffs in this case. And there's 3 issues before this court for review. The facts of this case are kind of unfortunate. Mr. Patton owns a duplex. He leased one half of the duplex to Miss Pearson. Miss Pearson lets a cat into the residence. One day, the cat is playing with a ribbon that's dangling off a table. The cat knocks the ribbon into a lit candle, which ignites the ribbon, which ignites a basket filled with inflammable craft supplies, which explode, which destroy.
So the ribbon sort of worked like a fuse.
Yes, Your Honor.
Into the basket.
Yeah, that's our understanding.
Causing an explosion.
Yes, sir. And that destroyed that half of the duplex. Mr. Patton, who resided in the other half, escaped unscathed. Miss Pearson was unhurt. The cat did not survive. But this is strictly a property damages matter. And this matter was dismissed on summary judgment on the grounds of the Sutton Rule. And, of course, the Sutton Rule is an anti-subrogation rule that originated in an Oklahoma case that basically said a tenant is an implied co-insured of a landlord, and therefore the landlord's insurance carrier cannot subrogate against the tenant. Well, in this case, the defense propounded requests for admissions and filed a motion requesting more thorough answers when the plaintiff objected to 3 of the requests for admissions on the basis that they dealt with insurance. And the defendant's position is, well, we know that there's insurance. Insurance paid the claim, and the insurance carrier is effectively hiding behind it's insured. And the name of the case is John Patton et al. Melody Patton versus Pearson. There's no mention of insurance anywhere in the complaint. An element of subrogation does not need to be proved to sustain the complaint, which sounds in both tort and contract. And so the court issued an order which is very brief and really had no legal grounds that required the defendant or the plaintiff rather, to supplement the discovery responses. And of course, these requests for admissions were used in the summary judgment proceeding, which led to the issue of the Sutton Rule. It's our position that the collateral source rule would apply. That the collateral source rule in Tennessee, the earliest case that can be easily ascertained is Anderson versus Miller, which is a Second Circuit Davidson County court case, just like this. So we've come full circle in 121 years. But in that case, the defendant filed a demurrer because we're under common law pleading at that time, and they said the insurance company's the proper party. The plaintiff has no damages, and the court said it doesn't matter. Insurance company can use the name of the insured. Doesn't matter if they received payments or didn't receive payments. And since that time, there's only been 2 enumerated exceptions to the collateral source doctrine, that being healthcare liability and workers' compensation. Otherwise, we have a robust collateral source rule in the state of Tennessee. So it's our position.
Natel seems a little problematic for you here. How are you distinguishing the circumstances here from Natel?
Well, so that's going to the second issue, is that there's sort of a trilogy of cases involving the Sutton Rule. We have the Natel case, which was the last case, really, in which this court addressed the Sutton Rule. But if we back up a few years, we have the Allstate versus Watson case. And in that case, this court applied the Sutton anti-subrogation rule. And when they applied the rule, the case was appealed to the Supreme Court. The Supreme Court found there was no right of subrogation because there was no liability on behalf of the defendant. And that case was Allstate versus Watson. It wasn't other party versus Watson. But then following the Allstate versus Watson case, we get to the Travelers case. In the Travelers case, it involved a sublease. And this court found that there was that the defendant shouldn't have any reasonable expectation of coverage under the landlord's policy because there was a sublease, also because there was competent testimony that the funds were not being used to pay the rent, and essentially the Sutton rule did not apply. And then we get to the Natel case, of course, where the Sutton Rule is applied. It's our position that it is an implication, that that the traveler's case stands for the position that it's an implication that can be defeated, not necessarily that without simply having that express written portion of the lease that allows for subrogation. Because then you get into the issue where when we talk about an anti-subrogation rule, it's not a novel concept. Sutton is typically limited to situations regarding fire insurance, but that's not necessarily the case.
Counsel, I wonder if, just try to focus you in on,
Sure.
I'm still struggling to see how this is distinct from Detel. And is your argument that we should ignore or disregard Detel, or is there a difference here in this case?
Well, no, I think that the law is somewhat unsettled because we do have the traveler's case, which actually found an exception to the previously applied Sutton Rule as it was applied in Watson.
Are any of the exceptions that you assert exist under Tennessee law applicable to the facts here?
Yes, there were actually a statement of undisputed facts or a statement of additional facts propounded by the plaintiff, and about 9 of them were undisputed without citations to the record, or were not disputed with citations to the record as required by Rule 5603. And these facts...
Was that raised before the trial court?
I'm sorry?
Was that raised before the trial court, the failure to cite?
Well, that was on... They should not have been considered by the trial court.
Did you raise an objection? Was an objection raised in this case to failure to cite to the record appropriately?
No.
But it's the first time it's being raised is on appeal?
Well, they weren't disputed, so they're undisputed for the purposes of summary judgment. That's my understanding. But the trial court should have considered them undisputed because they're not being disputed. But going forward, no, I think that also, because there is this exception, I think that the law is somewhat unsettled when we look at Daddle in the context of travelers. This case sounds in both tort and contract. And when we talk about the concept of anti-subrogation, it certainly does not apply in cases where there is not coverage available. And I cite to the Phoenix Insurance Company versus the state of Neal. And in that particular case, there was a subrogation claim made, and there was not coverage for the loss for which subrogation was being sought. And this court said subrogation is permissible. And we have a case that sounds in tort and contract. And I think that there's not necessarily coverage in most, homeowners' policies, or necessarily in this policy for a contract loss. Also, the whole point of the Sutton Rule is that you're looking to prevent waste. And in the Daddle case, this court discusses how you don't want an individual tenant, and say you have a 100-unit apartment complex. You don't want to require each tenant to insure the entire building. They're living in a single unit, and require them to have every tenant to have a multi-million-dollar insurance policy would certainly be wasteful. In this particular case, we're talking about a duplex, and there is facts in the record that undisputed facts in the record that Miss Pearson actually had insurance that did provide some coverage for a loss of this type. And so if we're concerned about the externality aspect of the Sutton Rule, this is on a much smaller scale than the Detel case, where we're talking about, potentially multiple insurance policies covering the same loss, putting a burden on renters. And of course, there is not a case, I do not believe, in the state of Tennessee that is on point as far as how the collateral source rule applies in these particular kinds of cases. Some states have case law that says, well, you can sort of peek behind the pleadings and sidestep them, and we're going to abrogate the collateral source rule for the purposes of subrogation. Some states do not allow that. And in Tennessee, we have Rule 17 of the Tennessee Rules of Civil Procedure. It says all matters should be prosecuted in the name of the real party in interest, except cases in which a party is subrogated to the rights of another. So there's some case law that says, well, that's just a matter of form over function. But then you have some case law that says, well, the fact that insurance makes a payment means that that doesn't mean that the insured can't recover.
Well, isn't one way to square the two rules is that the collateral source rule is a rule of damages, whereas the Sutton rule is a rule directed towards liability?
Well, I suppose you could parse it that way, but when we talk about the collateral source rule, it says that, the payments themselves are inadmissible for the purposes of reducing damages. But it's the collateral source rule because the source of those payments is also undiscoverable, inadmissible, because that's the source of the payments. And of course, the collateral source rule doesn't just apply to insurance. It also applies in any situation. Someone's car is damaged, a relative fixes it. You can still sue for the reasonable cost to make the necessary repairs or the diminution in value, whatever the appropriate measure is. There is not a case on point in that regard. And so to sort of summarize the 3 points that we brought today, I would say that the collateral source rule was properly invoked and that the trial court abused its discretion in granting the motion to compel. I'd say it's more of a motion to deem admitted, but function over form. And that there were disputed facts in the record that would have precluded the granting of summary judgment, or undisputed additional facts that would have precluded summary judgment in the record. And that's all I have on them.
Counsel, let me ask you a question. One of the issues you've raised about the propriety of the request for admissions in this case, I'm not sure I exactly follow how you're saying that the requests were improper. I mean, is it just because the request related to insurance? Is that what made them improper?
Yes, Your Honor.
Okay.
That's our position. Anything further?
Doesn't look like
All
it,
right.
so thank you.
Thank you, sir.
Good morning. May it please court, Cliff Wilson of the National Bar. It's good to be back in this building. I clerked here for Justice Phones many, many moons ago, so it was interesting going to the library and see where I used to sit and actually crack books, and before we had the tools we have nowadays. So it's good to be back here, and it's my privilege to represent the defendant in this case. And I would start out saying I would submit that there's really no dispute here between the parties as to whether or not the Sutton rule is the real rule in Tennessee. With all due respect to counsel, I think if you look at the trial court's memorandum decision in this case and the case that was cited by the trial court just some 6 months before she issued her ruling, Judge Crenshaw in federal court interpreting Tennessee law, and this is cited in the memorandum of opinion, he goes on and says that the TEL clearly adopted the Sutton rule. The Sutton rule applies. That is the law of the land in Tennessee. And absent an express agreement in the lease contract itself, the fire insurance carrier cannot go after the tenant for negligently causing a fire because that tenant is an implied co-insured. And that rule carries with it the prohibition of the fire insurance carrier from subrogating against the tenant for amount it paid out to its landlord.
Counsel, is there any direct language in the lease addressing insurance, how insurance will be handled between the parties?
There is the only language in the contract is that the tenant should buy insurance to protect her own goods. So there's no express agreement about protecting the landlord or the landlord's property. So I would submit that this contract lacks that express language that is required to get around the Sutton rule. And that's what the trial court found in this case. And I would submit when you take a look at the contract in this case, you will not find any express language requiring the tenant in this case to pay for the damages caused. And in this case, the damages were only, the tenant's only liable for misuse and neglect or something like that. And this is a little bit of a funky situation with a cat that was being fostered, knocking over a candle. I'm not sure if that's an abuse or neglect, but we don't really need to get to that far, because all we have to look at is this a subrogation claim by the fire insurance carrier against this tenant. And the landlord's fire insurance carrier tried to do an end around the Sutton rule. They filed this suit in the name of their insured, which they have a right to do, and they are trying to hide behind the name of the named insured. And I like the language from the young lawyer in the first case, trying to mask who they really are. They are, and it took me a minute to finally flesh that out, to find out who the real party and interests were. I tried to get a stipulation, couldn't get a stipulation. I sent requests for admissions, which are attached in my brief. They were objected to, say, oh, so this is collateral source. I don't have to answer this, which is a little bit odd, because answering these kind of things doesn't make them admissible. Answering questions about insurance doesn't make insurance admissible in the case if it goes to trial. But it clearly was an issue that was important to my client as to whether or not the Sutton rule is going to apply. If they had answered discovery and Mr. Patton says, I didn't have an insurance, I paid this, whatever, $100,000, $200,000, whatever the damages were, I paid him, we wouldn't be here, because the Sutton rule wouldn't apply. But when he admitted, as the trial court properly required him to admit, that he had property insurance, that the property insurance had paid this claim, and this claim was a subrogation claim, that set up what I needed to bring a motion before the trial court for summary judgment. And I believe the trial court's analysis, and that decision, and I know counsel picks at the trial judge saying, oh, that was an abuse of discretion for her to order his client to answer requests for admissions. Your honors know what the standard is for abuse of discretion, and I think if you take a look at this, this clearly was a good decision by her. It doesn't mean that the answers, if the case ultimately went to a jury, would be in front of a jury, but it gave me the information when I could put on the record what the real party and interest was in this case, and it was the fire insurance carrier of the landlord suing the tenant, and that's the whole rule. In this case, does a fire insurance company have a right to subrogate against this particular tenant? And in light of the American Reliable versus Addington case, which was cited by the trial court, which is Judge Crenshaw's decision, Dattell, the facts in both of those cases are virtually identical to the facts in this case. There's not distinguishable at all. Counsel tries to make a point, well, there really was some express language discussed at the Waffle House when they were making a deal about what the terms of the leasehold agreement is. The bottom line from Dattell, which is the Sutton case, says it has to be in the lease agreement. It has to have express language, not some conversation that took place at the Waffle House that they try to bring in. It had to be in the lease, and it wasn't there. And therefore, Dattell requires that the subrogation in this case that is being attempted, and I admire the good lawyering. I mean, I think that it's clever to try when they saw the problem. I think they were hoping that defense counsel would be asleep at the switch, not see the issue, pay the claim. And then when I did see the issue, then they became, you can't get this information. It's not proper for you to ask these questions. Don't look behind the curtain. This is only Mr. Patton filing the lawsuit. And we know what the real deal is. So respectfully, I think that the trial court got it right, and we'd ask this court to affirm the decision. Thank you.
Thank you. Mr. Payne?
When we talk about subrogation, there's a case that was handed down by this court on actually Valentine's Day of this year, Old Republic Life Insurance versus Woody. And in that case, Old Republic was attempting to participate as a plaintiff when its insured was also a plaintiff. And this court discusses how Such a position would require Old Republic to put 1 foot in its insured shoe and 1 foot in its own shoes, and that's not the law of subrogation in the state of Tennessee, that you're either both feet in the insured shoes or both feet in your own shoes. There's nothing impermissible about how the suit was filed. There was no objection to the form of the suit as it proceeded. There was no motion filed to say, well, the proper party is not before the court. And there's not really much case law specifically on point on this particular issue. There's nothing improper about how the matter was filed. And it's our position that the trial court erred in granting summary judgment on the bases we've already submitted. Thank you.
Thank you. Thank you both. Would you please adjourn court, please?
All rise.
We're not going out.
Yeah, no.
We're not going out. But court's over, okay?